Welcome, everybody, to the latest segment of The Break. This one is going to be on the legal requirements of document delivery. I, as always, am Brad Lachut, Director of Government Affairs for PI Northeast. I'm joined once again by Clare, Irvine, who is going to take us through this particular topic that we've been getting a lot of questions on recently. As we've seen some slowdown in the mailing system or the post office, this has become a bigger topic. So Claire is going to tackle this and hopefully give you all the information you need to know. So with that, Claire, I turn it over to you.
Great, thanks, Brad. Today's class, today's video is just kind of the cut and dry basic rules for legal requirements for document delivery. Many producers are responsible for delivering policies and insurance documents to customers. They also help customers return those documents either via the producer or directly to the company. And as Brad said, we've been getting a lot of questions about this. The combination of limitations with in-person interactions and the USPS delays have led to a lot of questions, specifically on when things need to be mailed and can they be done electronically. So first thing I'll cover is just electronic contracts. We frequently get questions about can policies be delivered electronically, and do electronic signatures count? There's two laws that together both mean that electronic policies are complete and electronic contracts, insurance policies or contracts, are completely valid, as well as a legal framework for using electronic signatures. It's a federal law that establishes electronic contracts and signatures and records are just as valid as non-electronic contract signatures and records. And then state laws based on the Uniform Electronic Transactions Act or similar statutes allow electronic signatures to have the same validity as the traditional wet ink signature. However, these should be thought of as an opt-in program. No person or company can be required to accept electronic delivery. They have to opt in, but once you opt in, you just have to do it once. If you have a customer that opted into electronic delivery a decade ago, they're still considered opted in unless there's a reason that would no longer be valid or they choose to, for some reason, opt out. So it doesn't have to be done every single policy year or renewed every so often. In order for electronic signature to be valid, there must be a clear intent by the person to sign. There must be a consent to do business electronically, and the signature must be clearly attributed to the individual. So that would be something like they're returning the document via their email address, or if it's a lot of companies now have online portals for security reasons, so if they log in using their username and password to consent to consent to sign documents, then that is attributed to that individual. You can opt into electronic policy delivery via electronic signature. I'm the type of person who's done that before. And I'm sure many of you have frequently, because some of it is just, click yes, put your signatures, put your initials in, done, get the policies delivered to your inbox. So it's not, you don't have to fill things out, print them, sign them, fax them, learn what depending on if you're trying to deal with Gen Z, explain to them what a fax is, etc. Just can all be done via email and as quick as you can get it done. As I said, though, that's all an opt-in system. So you may still have clients who prefer to do things via snail mail or the USPS, FedEx, UPS, or another delivery service, or who also may pay their policies by written check as opposed to EFT or credit card or another electronic method. So in those cases, the default rule is that a contract and or payment is deemed delivered when the sender mails it. So if you're making a policy payment via check and it's due on the first of the month, you write it out, your client writes it out on the first of the month and puts it in their mailbox, that is when it's considered delivered to the carrier. However, this being the default rule, it can be altered via contract, which again is the policy terms. So it's really important to read the policy terms and be familiar with other information sent by your carrier or their policy or what their expectations are, because you don't want to get into a contractual dispute over something like that. Even the question of what is the contract versus notice is something that's on a bar exam. It's not something you probably want to be dealing with. That way you can advise your clients that payment, if they need to pay by check by September 1st, it must be in the mail it must be received by the carrier on that day because of the policy. So, and same with if they're accepting the policy, signing the policy for insurance that way, and needs to be to the carrier by a certain day, that way you know about it. And also, it's called the mailbox rule because it's technically when you put it into a mailbox. Just as a best practice, there should probably be more proof that it was put in the mailbox if that rule applies than just taking a selfie in front of the post office when you're putting in a letter. That would probably create much more of a headache than just going down to your local post office, and they have easy options for confirming that you're sending it that day. So, and again, these are all just the basic rules. You can get into, have very fun going down a lot of hypothetical routes about what finding all the limitations. That's what law exams are for. It's not something I think most insurance producers want to be dealing with. And if you do have an issue on these topics, it's probably best to consult an attorney, or which is also, you can call Brad or I if you have a specific question on a specific instance. Or if you have further questions on this issue, you can also contact the PIA Resource Center, and we'll have several PIA resources on these issues are linked to below. Brad, do you have anything else to add or further questions?
Just one thing to mention, you mentioned opting in a couple times, and just to let everybody know that clients can opt out, and you did mention that, and they can opt out at any time, which is something that members should remember, that if a client no longer wants to receive documents electronically, they can opt out at any time, then you have to send it to them the old-fashioned way. So just a reminder there.
Yeah.
Not sure why somebody would do that, but maybe they will.
It's a great point. And you also still have clients who probably, they might receive things via email, but still want a hard copy of it. They may not have the ability to print it themselves. So kind of having open lines of communication are good. But again, these are the default rules. If you have further questions, feel free to ask them.
All right. Well, thank you, Claire. I appreciate the information. This is good. Definitely, like I said, we've been getting a lot of questions on this. So hopefully this was a concise recitation of what the issue is and people understand it. And as you mentioned, if anybody does have any questions, contact myself or Claire. Please contact Claire, actually, or the Resource Center. Anything else before we close out here, Claire?
No, I think we're good.
All right. Thank you again, Claire. Appreciate it. And we'll see everybody soon for the next edition of The Break. Bye, everybody.